start with the presentation, that would be great. My name is Elizabeth Capuano. I am an advisor to international students and scholars at the Harvard International Office. And we thought that this would be a good session to have today so that we could talk about particularly difficult issues pertaining to F-1 employment. So this is a presentation that is primarily designed for people who have some experience with advising F-1 students and really have a grip on the basics of on-campus employment, curricular practical training, CPT, optional practical training, OPT, and also the STEM OPT extension. So we're going to hit on a few specific scenarios that you may encounter. We're going to talk about how our respective institutions might handle some of these issues. And we're also going to point you in the direction of some specific resources that you should be reviewing when you're encountering these issues so that you can work out a solution that will work for you and your institution and that will hopefully be able to assist the student in accomplishing their academic and professional goals as well. So Nicole, if we could move over to the resources slide, that would be great. Some of the resources that we're going to refer to today include the NAFSA manual and listservs. The NAFSA manual is a wonderful resource. I refer to it, as I'm sure my colleagues do here, several times a week. Sometimes, to be honest with you, even for common issues I haven't dealt with for a really long time, to make sure the information hasn't changed. It consolidates all relevant government resources from SEVP, USCIS, the State Department, DOS, and it has really helpful bookmarking tools so that you can go back to frequently used sections. If you don't have access to the manual, I think that this is a period of time where it would be useful for you to consider how to best advocate for yourself and your office to obtain access to it. In some of the other presentations and panels that I've attended and spoken to people about, people have been talking about trying to share access to the manual with other offices so that perhaps that fee can be split or shared among budgets. People have been talking about asking, since we're not traveling and since we don't necessarily have a budget that is going to professional development, could we put that money towards this instead? Those are a few ideas that you might want to consider and think about when talking to your colleagues about obtaining access to the manual if you don't have it already. The study in the states page is also, I think, a really great page to go to, especially if you're trying to find consolidated information that students can refer to in addition to your office's website. It also has helpful information that employers can refer to if you're dealing with a STEM OPT or OPT issue. I also make use of the handbook for employers sometimes, which is known as the M274. This can be useful for I-9 issues. Again, if you have a student who is trying to communicate with an employer about an I-9 problem, some of your offices may actually be the I-9 hub for your institution. Mine is not, so this has been useful for me to kind of stay on top of some of these issues and be aware of them as they may come up for students. Finally, local social security offices are someone that hopefully you have a contact with a local social security office that you can be in touch with on an as-needed basis these days. Issues for social security numbers certainly seem to be based heavily on local offices and the way they are choosing to administer processes these days. And finally, we also hope that other DSOs will be a resource to you. I see a lot of familiar names in the meeting today, which is great. I wish I could see all of you in person, and hopefully that will be the case for next year's SIW. But I also see some new names and people from other institutions that I don't think I've met before. So welcome, we're really glad you're here. And with that, I will turn it over to Shannon, I think, who is talking about on-campus employment.
Thank you, Elizabeth. If you could move one more slide, Nicole, that'd be great. I just wanted to talk real quick about on-campus employment because this is the least sticky of all of the kinds of employment that we deal with and talk about because there's no authorization necessarily needed from a DSO, but some issues that have been problematic this past year, especially because of COVID, are an uptick in working remotely, even for student workers. So your F-1 students who might be working in locations on campus that allow for remote work might be doing this. So it's okay from a F-1 regulatory perspective, but all rules do still apply for maximum hours allowed at any given time. So institutions might have different rules, but as far as F-1 rules go, there's not a problem with this. Working remotely out of state or out of country can get messy as well. Like the previous point, it's not really a DSO concern, but could be a concern for tax purposes for your institution. So you might want to have a conversation if you haven't had one already. I know we're a year into this, but if you haven't had one already, you might want to talk with your student employment office, your HR office, your comptroller's office. Export control could be a problem depending on what offices those students are working at. So you might just want to have a conversation with your partners and other stakeholders on campus so everyone's on the same page serving your students. And then there are some relevant on-campus employment citations here. I did see a question pop up in the chat. This is being recorded right now, and we are happy to share these slides at the end. So you'll be able to click on these links and view the resources. So it's a mix of SCVP resources like Study in the States and also the CFR. So the CFR can also be found in the NAFSA manual, this 360 advisor manual, and can be really helpful for the conversations that you'll be having with other people on campus. So we can move forward to the next topic, and I'll hand it over to Anna.
Thank you, Shannon. So I am Anna Garson. I'm a senior advisor at Bentley University, and we're going to start the practical training portion of our presentation today. So CPT is a notoriously gray area in the regulation, which both works in our favor sometimes, but can also be difficult when we're looking to give concrete answers to students or stakeholders, or if you're trying to establish a program that works for CPT for the first time. So I wanted to start off our discussion of CPT with 3 regulatory clauses. And I wanted to start with this because they're probably clauses that we've all heard before, but they do carry some nuance, and they also highlight the importance of both documentation and institutional policy when it comes to CPT. So firstly, I wanted to start off with the infamous phrase, integral part of an established curriculum. So we've all heard, or most of us have probably heard that before. It is quite a mouthful to say, yet it says so little, or is not super clear as to what it means. So for most institutions, that either is interpreted as a program requirement for or not for credit, but a requirement or for course credit. So different institutions have different models. And I know that when preparing for this presentation, I talked a little bit with Shannon and Elizabeth about some of the benefits and disadvantages for both of those models. And I'll have them share in a few minutes how their institutions authorize CPT. But just keeping in mind that if you're making it a course for credit, that it should be offered to all students, not just international students, for multiple reasons, one of which being equity, amongst domestic and international students, particularly if you're offering it for a fee, making sure that it's not just a CPT course, but a true internship course. And that goes back to that established curriculum piece. And then if you make it a program requirements, that's probably quote unquote easiest way to do it, and also make sure that it is addresses the equity issue amongst international and domestic students. So again, it really depends on your institution. It's all about institutional policy and making sure this is documented. So if your students or institution are ever asked, you can refer back to your institutional policy that it was part of an established curriculum. The next clause I want to talk about is that it is directly related to the student's major area of study. So this is probably the least nuanced of these 3 clauses, but I think it's important to mention because there is guidance that states that it is okay if it's for a specialization So for example, we are a business school at Bentley, and even in the guidance that is offered, it says, you know, if a student is doing, for example, an MBA program and has a specialization in marketing, not necessarily their major, but a specialization, and there's an internship within that marketing department, that is permitted. It gets a little wishy-washy when you're talking about CPT for an elective credit, just because it's not clear maybe from that course itself that it is directly related. At Bentley, we do have an internship course that is done for elective credit. The way that we address this is on our CPT form itself, which is filled out by both the internship coordinator in the academic department and the student. We have a section where the student lists the way in which it is related to their major. And then that's also reinforced by the offer letter that we get from that employer. Which brings me to the next point. There is this clause about it being a cooperative agreement with the school. So this actually boils down to a grammatical issue within the regulations. It's unclear based on the grammar of this sentence whether CPT requires a cooperative agreement with the school or includes in cases in which there's a cooperative agreement. Regardless, it is best practice for most schools to accept or to request an offer letter or an employer letter when students are being authorized for CPT, which in itself sets up you know, this aspect of cooperation between the employer and the school. So before we move on, I'm just going to very briefly have each of our presenters today just share at their school how CPT is authorized. So at Bentley, we don't have any required internships, but it is offered as a course for credit. Students generally are eligible for anywhere between 1 and 3 courses. And it is by academic department. So I'm just going to have Shannon and Elizabeth share very briefly.
Sure, thanks, Anna. I'm at Northeastern, and Northeastern is obviously very well known for the co-op program that's offered. So pretty much all of our students do CPT at one point or another. Not 100%, there are some programs that do not require it. But for those, we do offer elective courses if students choose to do one. So every department or every program has their own co-op course, and those courses, that's the course we look for when we're authorizing CPT. The student must be enrolled in the co-op course that's appropriate for their program. We ask for offer letters, and we have the co-op coordinators sign off on all CPT applications before we create an I-20. So because it is such a integral part of the culture at our institution and of all of the academic programs, it's maybe a little bit more straightforward because it's so ingrained already in the academic culture of our institution.
So at Harvard, the CPT requirements and opportunities vary considerably from school to school because each school has such drastically different educational models and student needs that it wouldn't be possible for us to take a one-size-fits-all approach to CPT. I advise students from the School of Public Health, and there are a number of programs there. The Master of Public Health program, a number of Master of Science programs, and the Doctor of Public Health program, all of which have some kind of, or nearly all of which have some kind of experiential learning requirement. The Master of Public Health program has a required practicum. This is very much documented in its program manual. I also think that it has some bearing on the school's accreditation for that program. The master's programs usually have some kind of collaborative research practicum or something along those lines. Each program might call it something slightly different. But in those instances, it's pretty straightforward. The students receive CPT authorization for that. Some of the master's students are in longer programs. They might be 3 or 4 semester programs, and they may opt to do off-campus internships. But when they do so, there are requirements for them to enroll in independent study courses. And to ensure that these courses are meeting sufficient academic standards, the program director of each master's program is the required signatory on the CPT application materials to me. And this ensures consistency in terms of how many credits students are enrolling for. And like I mentioned, what the academic standard is going to be for that independent study program. For a while, we had tried doing it with individual faculty members and adjunct faculty possibly signing off on it because they were supervising the particular independent study course, but that didn't seem to be working out. So I was able to talk to faculty about what they thought would be best, and this is what we were able to come up with together. So that is sort of like our elective CPT option. And fortunately, independent studies, as Anna pointed out, are available to any student. So that was also kind of a nice way to keep things consistent.
Wonderful. Thank you, Elizabeth and Shannon. So we are going to move on now to also a question that I'm sure many of you have received before by students. What if my internship is unpaid or volunteer? So unfortunately, this is a hard question because we would love for our students to be able to get that experiential education. It seems unfair that international students need authorization for an unpaid internship, but I think I think a lot of schools have gone with the conservative approach that payment should not be a factor when authorizing CPT. And if you're trying to explain this or deliver this hard news to students or stakeholders or even to an employer, I think it's good to know where this comes from. So there is the SEVP field response. So the field has spoken and said that if it meets the definition of CPT, then it needs CPT regardless of pay. And that's also reinforced by the DSO training module, which says that compensation should not be a consideration when determining the need for CPT. And apart from that, the other layer is labor laws and the definition of employment. So the definition of employment does not exclude unpaid work. And along with that, there's the Fair Labor Standards Act, which sets certain standards to determine whether an intern or a student is an employee of the company. It talks about the primary beneficiary of the relationship and therefore compensation requirements. So again, because this does boil down to also labor laws, this could have serious implications for an employer in terms of taxes and fines, and also for the student as a status violation. So it is not up to the student or the employer to say, we're just not going to pay this student, whether it's for financial reasons or to circumvent the need for employment authorization. So if we move to the next slide. So continuing along this point, when doing some investigating on this topic, I really liked this grid here that really highlights how working and income are two very different things. So you have the Department of Homeland Security definition of employment. You have the Department of Labor definition of volunteer, which has actually a 7-factor test to determine whether an experience is truly a volunteer experience. And then also I like to mention the IRS's criteria for active versus passive income. So this is less of an issue for students who simply want to do unpaid internships and more of something that's helpful when students are coming to you with non-traditional arrangements or non-traditional employment, quote unquote. So students who want to do trading or investing, buying, selling, publishing, things like that, that don't necessarily meet our usual understanding of what it means to be employed. But the IRS criteria gives you a little bit of an understanding of what could be considered active income and therefore may need employment authorization. And again, there may be some passive activities that may not. So it boils down to the fact that some unpaid activities are considered work and need authorization, while some activities that may result in passive income may not. And this is an incredibly sticky issue. And we at our institution try to avoid giving students clear-cut answers when it comes to non-traditional things like this. When in doubt, get authorization or have your student or your office consult with legal counsel or an immigration attorney. And also just be sure that you tell students that if they're considering putting it on their resume or LinkedIn, then that is easily available information to a USCIS adjudicator. So if they are getting employment, they should get employment, or they should have documentation collected proactively for the reason why they're not for that particular experience. So moving on to our next point. So I will go through this quickly, although there are quite a number of words here. So most of us know that there is the need for one full academic year prior to a student being eligible for CPT. So most of us are familiar with the standard. You've been in F-1 status for one academic year. But it also can include other situations, such as students who have transferred to your institution or were engaged in other programs without a break in between, or students who are studying in full-time status in another immigration category, as long as they are in F-1 status at the time of authorization. Also students with reduced course load. So RCLs are cited multiple times in the regulation as being full-time equivalent. So that covers them. So just because a student had a previous reduced course load doesn't necessarily mean they're not accruing eligibility. Students studying abroad, and then also with COVID, students who are in active status, whether they're in or outside of the US, they are accruing eligibility. Not initial students if they're not here yet, but active students are. Again, as Shannon mentioned, with on-campus employment, just keep in mind if students are actually working outside of the US, then there could be tax implications for the employer. So moving forward, very briefly, it doesn't include students with gaps between programs or who were studying unauthorized, part-time in any status. Reinstatements are somewhat ambiguous, but in most interpretations, reinstatements are considered restoration of status, and therefore an approved reinstatement would mean that their eligibility for these benefits is not affected. So moving forward, I wanted to touch briefly upon immediate participation in CPT because there is the exception that for a graduate program, if the internship or practical experience is required, then it can be authorized before that one academic year mark. So just beware and you're advising to students, and also if your institution is considering doing a program that requires an internship from the very start, that the government has been pretty clear that CPT isn't meant for students to continue current employment in the absence of eligibility for other types of employment authorization or sponsorship, or to increase international student enrollment. So we all know those day one CPT programs where many of our students transfer to at the end of the summer, the end of the CAP season. But just because those institutions are able to take advantage of gray area, it doesn't necessarily mean that those institutions are not on Homeland Security Investigations radar already, which could be detrimental to both the school and the student. So some other sticky issues, CPT and on-campus employment. This often comes up at conferences, whether schools allow both CPT, which is or both on-campus employment, which is capped at 20 hours per week during the academic year, and CPT. So there are actually two distinct parts of the regulation governing each of these. So just because a student has an on-campus position, perhaps for 20 hours per week, doesn't necessarily mean that they cannot do CPT in addition. CPT is curricular, so it's a part of their curriculum. Again, institutional policy is separate. So if your institution decides that they should not, then obviously that trumps the regulation. So full-time versus part-time, some schools also don't allow full-time CPT during the academic year. Bentley does. We just remind students that you need to be in a full course load, including or in addition to that internship. And also remember that 20 hours per week is part-time. So if a student may be at risk of going over that during the course of their internship, consider authorizing full-time, since that cannot be retroactively changed. Proofreading CPT authorization, as I mentioned, really hard to change retroactively. Have students take a look at their I-20s. And lastly, the physical presence requirement. So for example, at Bentley, we do allow out-of-state CPT in the summer when other in-person coursework isn't required. And we have had students who have done CPT in Connecticut and been able to commute for their other classes. That may be something that you want to have a policy on. And remember, remote work is allowed. SAVP has been clear about that with COVID-19. However, for CPT, it has never necessarily not been allowed. So that very quickly covers a lot of different sticky issues with CPT. So now I'm going to pass it along to Shannon with optional practical training.
Thank you. So I guess before we talk about anything else, we obviously, when we're talking about OPT, we have to talk about our current, where we currently find ourselves with the Texas lockbox incident. I feel like it's a Nancy Drew novel, like, you know, NAFSA and the Texas lockbox incident. So I updated this after we got our 4:30 surprise last Friday about how USCIS is handling the current situation with Texas. So the email on the 26th last Friday has laid out some really important areas of flexibility, and that information is available on USCIS's website. We know students have heard about this as well as us, so everybody has the same resources right now and has been looking at it very carefully. So we can touch on a couple of the really important issues, but before I do that, I want to make the point that this doesn't answer all the questions. There are still questions. And so if you find yourself in a situation where the guidance that was given last Friday doesn't fully answer your question, we still encourage you to reach out to our fabulous Reg Buds or to the listserv on NAFSA that is great. There's always lots of good conversations going on there, or to other institutions and just say, how would you deal with this? And hopefully we'll see NAFSA, GRAC. I know Ayla has been doing a lot of work. Hopefully their advocacy will get some clarification as well. But basically what we've been told now is that USCIS will allow the 14-month period of, eligibility time to commence from the date of approval rather than the end date of the program. So this is a big deal for students who have been severely delayed because of the lockbox. So I know that was a welcome piece of news. There's also implications here for refiling after an application has been rejected for any particular reason. So if you have a student who had an OPT or a STEM 765 rejected between October 1 of 2020 and May 31st of this spring, you still have the option to refile, even if the appropriate time period has passed. There is some flexibility there, as long as the refiled application is received by May 31st. They are accommodating that. You will not need to include any new I-20s with a refiled rejected application. So if you have someone who you're no longer able to create a recommendation for because of the window of time has passed, that's okay. The student can still refile with the previous I-20. So you just have to make sure that they follow these other important rules here. And instead of denying or outright rejecting applications that have signature problems, which we have seen, USCIS has indicated that they will begin using RFEs in those cases instead. And thanks, Elizabeth, for putting that in the chat. It looks like they are working through November right now. So hopefully things are picking up pace, but there probably is still a very large volume from late November into December. So it's nice to see some movement though. You can move on to the next slide. This was another fun and lovely thing that we had to deal with in 2020 when SCVP decided, hey, it seems like a fun time to test the waters with auto terminations based on unemployment time. And we are still unclear at this time how they chose which records to target. At Northeastern, we had about 20 SIWS records terminated by SCVP for exceeding the allowable unemployment time. The other problem that happened, and maybe your schools lucked out and didn't have any records caught up in this, but if you did, then you know that it was incredibly painful because SCVP flip-flopped around a little bit about how they wanted to handle those records. At first, they indicated that if a record was terminated for exceeding unemployment time, that was it, there was no recourse. Then they changed their minds and allowed for data fixes if the student could prove they had been employed during the time and had not, in fact, exceeded their unemployment time. So it was a little bit chaotic, to say the least, and confusing and frustrating for DSOs and students and employers, and probably the SRC as well. So it was really confusing, and it hasn't happened since that first time, as far as I'm aware. What we've been doing is we've been from time to time checking the SIWS termination list to see if any records have been terminated recently for the reason of exceeding unemployment time, because without checking, there's no way to know. So that's what we've been doing. But that's all we've been doing. And we've also increased our communication to our students and increase the sense of urgency in that communication when we communicate with students about what their responsibilities are. So we'll take this moment to talk about how each of our institutions handle this. And obviously it will totally depend on your institutional culture and the resources that your office has available about how handholdy you can be with students and how much time you can use to run reports and send out individualized communications to remind students to use the portal or to report their employment or how important it is. It also depends on how risk averse your school is. So it will really vary from institution to institution how you can handle this. So at Northeastern, we have Synapsis. We're lucky enough to have a system for this. And what we do is we use the functionality within Synapsis to send out automated emails to students on OPT and on STEM OPT to remind them of their reporting responsibilities and how they can report, whether it be reporting to our office and to a DSO or reporting directly in the portal for those who have that available to them. For STEM, we also remind them about validations. But just because we send the email doesn't mean they follow through. but with such a large caseload, we have over 5,000 students on post-completion or STEM OPT at any given time. There's no way that we can follow up individually with students. So we rely on these auto communications, and from time to time, we'll send a large mass communication to remind students. Anna, what do you guys do at Bentley?
So at Bentley, we have a much smaller international student population. So we have under 1,200 students, closer to 1,100 right now with COVID. But we do send out, and those on OPT, we have about probably 300, 350 on OPT and STEM OPT. And we do send out periodic email reminders when we have the bandwidth, although we tell students not to rely on those. We actually have students at the point of application fill out an acknowledgement form that reminds them of their reporting deadlines. And for STEM, that also includes a date calculator so that they can calculate their reporting deadlines and put that into their calendar at the time of application. So we do a mixture of, again, reminders and then putting the onus on the student by having them fill out that acknowledgement form.
And then at my institution, we have a number of resources that we use when it comes to OPT reporting. We send out periodic emails throughout the year to remind students of their reporting obligations and some of the other issues about OPT, like what they need to do when they're traveling and whatnot, and reporting reminders are included in that email. And what we've also been doing for the past few months is we have been running lists in SIWS to be able to see how many days of unemployment students have accrued during their OPT period. And we have been targeting students who seem like they're missing reporting information by running lists, dividing up those lists among the HIO advisors. So since I have the School of Public Health, I get the full list of HSPH students who are coming up on reaching that unemployment date, that unemployment max. And then we have template emails that we send to them to remind them of their reporting obligations. And for us, this has proven to be very effective. Back in November, we had just under 100 students who were really running into problems with reaching that unemployment limit. And now with this last month, that number was reduced down to only 5 students who were exceeding the unemployment limit. So we've really tackled this consistently, and we feel like that's yielded some really positive results for our students in terms of assisting them with maintaining their status. And for us, I think some of this effort comes from a couple places. I think, we see our office as having a role with the schools in terms of helping students, being proactive and assisting them and reminding them of these requirements on a regular basis. When we send out the reminders, we do say, this is part of your status maintenance. So we remind them of their obligation to report. And I also think, this is a good opportunity to remind ourselves about reporting and the regulations. And if you go back into the regulatory language, the way it is structured is it says that the student is required to make the report to the DSO. So that's part of the reason why we're very reluctant to rely solely on the portal, which we have not talked about at this point, and we can hit on a little bit here. But the regulatory language says that the student is required to make the report to the DSO, and then the DSO is supposed to enter that information into the student's SIWS record. So I think we see that, or this process is kind of complementing that part of the regulation and ensuring our compliance with that part of the reg, because we're going back to the student saying, hey, you have to get this information to me, the DSO, and then we go and update the information in SIWS.
Thank you guys so much. And I just want to make a comment about the portal as well before we move forward. So there, unfortunately, there's a well-known disparity and issue here about who's responsible for what. the regulations say that the student has to report to the DSO, but then SEVP opened the portal, and the reason that they gave to us for doing that was to make the student responsible. But then we saw back in the fall, or the late fall, right at the end of 2020 there, some rather aggressive language coming out of USCIS and Department of Homeland Security spokespeople, being very aggressive to DSOs and accusatory to DSOs of breaking the law. So I think there's a lot of advocacy that needs to be done in the area of clarifying responsibility and who that falls on. So I hope to see some changes move forward, and we'll talk a little bit about the SRC and SEVP a little bit later, but hopefully we're on a positive track moving forward. So here are some additional issues that have come up with OPT. Remote employment, as we know right now, is permitted for the duration of the pandemic, with no changes to how it should be reported within SEVIS. Auto terminations happen when claims fails as a system, which I would say is incredibly common. So if the claim system doesn't update the receipt information in the SEVIS record, records can be auto terminated or auto completed. And that is a long-standing problem between systems. I don't know what to say other than it will probably continue because we've been complaining about it for a long time. So be watchful for those issues. It can be easily corrected through the SEVIS correction management tool, which means you don't even need to call the SRC to fix it. If you notice it or a student is unable to enter their portal because of it, all you have to do is do the correction management and upload copies of the EAD or the receipt, depending on how the timing works out, and those corrections go through pretty quickly. So the thing to be aware of is if a termination happens, that's an error, SEVP will stop emailing the student about reminders or the portal. The student might not ever receive a message about the portal. So it's just something to be really aware of. Again, with my Nancy Drew case comment, we saw the case of the whiplash broadcast right at the end of the Trump administration and moving into the new Biden administration, where first a task force for employment fraud was announced and then quickly rescinded. So maybe we don't have to worry about it right now, but it's a good reminder that maybe you want to talk about it with students, even if this task force is never going to come to fruition or isn't going to come to fruition right now. That doesn't mean it doesn't happen in the future. There are different ways to discuss how Homeland Security might monitor your students' employment. So maybe your office might want to consider, do you include that in your OPT marketing or OPT paperwork or handouts or website? Do you want to mention to students that it is possible that Department of Homeland Security might investigate for employment fraud and they need to be aware of that? So that's just something to think about and something to keep in mind, that they do check, and people shouldn't be taking it too lightly. I think we can move ahead. I think this is the last one for regular OPT, for post-completion OPT. There are some sticky things that happen with CapGap. Again, that's really common and long-standing problems. We often see, I don't know how often, but it's common that we might see consular processing and in-country change of status get mixed up and confused within the system. So sometimes SEVP will get it wrong and complete a record that's supposed to be for consular processing. And that can just be corrected within the corrections management system in CVIS as well. And there's some issues with CAP-GAP. Students obviously really jump at the chance to request a CAP-GAP I-20. So we talked a little bit about some differences between our institutions for what we request from a student. At Northeastern, we asked to see the 797C before we will attempt to make a CAP-GAP I-20. What do you guys do at Harvard, Elizabeth?
We have a specific CAP-GAP request form that we require students to submit to our office. And that form does also request the approval notice so that we can take a look at it. And it requires the signature of an employer's representative or the attorney who assisted with the H-1B filing, because sometimes this is also based on the receipt notice, which also doesn't necessarily indicate which type of H-1B filing you're looking at. This has been a big issue for our students because one thing that has come up quite frequently for us is that students will consular process the H and will prefer consular processing so that they can hold off on the H activation and maintain the F-1 status to use STEM OPT to buy themselves some additional time before traveling, or for whatever reasons they may have that they've discussed with their employer and their immigration attorney. So we do ask to see that information as well.
Thank you. So I think that's it for post-completion. So I'll hand it over to Elizabeth for STEM.
Great, thanks, Shannon. Nicole, if we could move over to the STEM slides, that would be great. One issue that I think is really important to talk about that Shannon started us with is the issue of the receipt notices. And that has come up quite a bit for a number of our students with the question, can the student continue working and be I-9'd by the employer if they have not received the receipt notice? The answer here is actually yes. And I think this is a good example of when to look at that M274 manual, which is why I wanted to highlight this. It's pretty clear in that manual that the student has to provide their employer with the unexpired passport, the I-20 document that includes the STEM OPT recommendation, and their I-94 record, which should certainly include F-1 DS on it. And they bring that to the employer for purposes of receiving the I-9 extension for the 180-day period while the STEM is pending and after the 12-month period of OPT has expired. And I think what we've encountered from time to time is that sometimes employers may have varying experience with I-9 completion, especially for small companies, smaller nonprofits, startups. These are all kinds of situations we've seen in which the employer may not have the experience yet with the I-9 processes, and they feel uncomfortable, doing the I-9 extension without having that receipt notice. But the fact of the matter is, it is not a requirement for them to have that receipt notice, excuse me. I think this is also a good point in time to kind of point out that, my office and my colleagues and I will put this information in an email to the student. I frequently refer to a PDF of the M274 manual and will email that to them, but I don't speak to the employer directly about these issues. My preference is always to work directly with the student, to convey the information to the student, and then the student can bring that information to their employer. Because I see my role, and I think we would all probably agree here, that my role is to provide advising support to the student, not to provide advising to an employer about how to properly complete and maintain their I-9s. So I think that that's an important distinction to make here, and an important thing for us to be considering about our role when we're talking about any employment issue, quite frankly. So that's something that's come up from time to time. And to be honest with you, when I provided the student with this information, I usually don't hear anything back, which to me says that the situation has probably been resolved effectively. So that's just, I think, an important point to bear in mind about the issue of receipt notices and the I-9 from the STEM extension. If we could move on to the next slide. One thing that has come up occasionally is for STEM extension issues is employment terminations and what is required when a student is ending employment with a STEM OPT employer. And this is a helpful situation where I've gone back to the Study in the States STEM OPT hub, because it really does a good job of breaking down what the requirements are for the student, the employer, and the DSO. So I find that breakdown to be fairly useful. And I feel very comfortable providing this information to people because it's all public. It is based on federal regulations. It's not a matter of Harvard policy or preference. It's simply what they're supposed to do. And it's documented on a government website. So it's information that's being provided consistently and across the board to all of these stakeholders. So I think it's a particularly useful resource to bear in mind. When it comes to the employment situation, the employer is obligated to report that they know employment has ended. I tend not to hear very much about this from employers, and I don't really hear back from them with any regularity. Every so often I'll get something, but not very often. And it's hard for me to know why that might be the case. My office requires an employer attestation. When we're processing STEM requests from students, we ask the employer to sign off on an attestation indicating that they understand what their obligations are pursuant to the STEM requirements. Sometimes I think maybe employers aren't paying attention or handling issues consistently, but sometimes I think, well, maybe these types of terminations just aren't happening with a great deal of frequency either. So it could be a little bit of both. Students are required to report that they've ended their employment within 10 days of ending it. I remind students of these date timelines as frequently as I can in my communications with them when they're talking about ending employment and changing employment. And we do the best we can to help them be aware of these things by reminding them of it. I don't think it would be necessarily possible to start really splitting hairs and getting into specific date timelines about when someone's ended and when did you receive the I-983. I think that would be very difficult for us to track. But in this situation, our focus is on advising the student and the employer when applicable of their obligations. I know one thing that our office has done is we send out periodic reminders to students directly about their STEM OPT reporting obligations, the 6-month reports, as well as the 12 and 24-month obligations. These seem to be pretty effective. We have a system where students receive a couple of reminders at each point in time, and we have an advisor who is dedicated to reviewing this information in CVIS and sending out these reminders to students. And I'm wondering if Anna and Shannon could speak a little bit to how their respective schools handle some of these issues with reporting and making sure that they get information about terminations if they need to.
Sure. So at Bentley, I mentioned it a little bit back in the OPT section, but we do have students sign an acknowledgement form that has the dates that they're due for reporting. So that is one way that we make sure that students are aware of their reporting deadlines. We also send out periodic email reminders. There's also that automatic reminder that is sent from CVIS now, which is helpful, but also somewhat problematic in that it says, review the information and confirm it is correct, which is not what our office generally does for STEM validation reports. We actually have a form that we have students submit, an online form that validates that their information has remained the same. So it's helpful in that if they're checking their email, they may have a reminder that they have a reporting deadline coming up. Not so helpful in that it's not school specific, so it doesn't list our process. Just like Elizabeth mentioned, we also don't generally get emails from employers when students stop working at a specific employer. And we don't have any sort of form for the employer to sign at the beginning of a STEM OPT process, acknowledging that they understand their requirements. We take the signature on the I-983 to imply that they understand this requirement. So generally, it's students who are updating us when they end employment at a STEM employer.
Very similar at Northeastern. So like I said, we have Synapses. So the way things are set up with Synapses is there's we can set up reports or automated emails for when students require validation. They submit an e-form to us for validation, so we can go into CVIS and complete that process. Sometimes we hear from employers when they have separated from one of our students. In those cases, we just say thank you, we'll follow up with the student. But other than that, we really avoid dealing with employers in any circumstances. That's not the job of a DSO. The job of a DSO is to work with the student. So we really try to avoid working with employers directly. So we ask for all reporting to go through the student.
Just to piggyback on that really quickly, we have made a guide for both students and for employers. The employer guide is actually pretty general, but it does list, it has a grid that has the employer requirements for CPT, OPT, and STEM OPT, and some general information, which we found has been helpful and has mitigated some of the requests that we get from employers for information.
That's great. Thank you guys for sharing that information. Nicole, if we could move to the next page about remote work. I'll go through this pretty quickly because I think this is pretty clear. Right now, international students are permitted to work remotely during the STEM extension. And that's, I think, pretty clear in the guidance. We have the links to the guidance about this information here. I think it's also important to bear in mind, though, that once this guidance is rescinded, presumably once this pandemic is over, students would likely be expected to return back to the work site that is indicated on the I-983. And to something that Shannon had raised in her section about OPT, it's important not to lose sight of that, because during the STEM extension, there is the option for the Department of Homeland Security to conduct a site visit. And this is something that is pretty clearly established in the STEM rules and the STEM guidance that we see on Study in the States, in the regulations, and I think it's probably the preamble to the STEM regs. I'd have to check on that. But this is documented, and if you have a student asking you about remote work, I think it's useful to point that out and remind them of that possibility. If we could move to the next slide. This is the last thing I'm going to go through, I think, substantively on STEM, because I'd like to leave some time for questions so that we can have a bit of a conversation or address more specific info about some of these topics. One issue that came up for me this year was the issue of unpaid leave. I had a student on a STEM extension who was taking an unpaid leave to be able to prepare for the USMLEs. And it was one of those situations where I didn't really know what to do with it. And at the recommendation of a colleague, I went back to the regulatory language. And in the preambles to the regs, the STEM regs, it is clear that the Department of Homeland Security expects for there to be a bona fide employer-employee relationship and that a student can't be self-employed. So I knew he wasn't going to be self-employed. The term that he kept using was, I'm taking an unpaid leave, which presumably was the employer's policy or term for the way that they were implementing a policy. But I didn't know what that meant. So I said, well, what have they provided to you? You know, like, I need to understand, like, what do they mean by unpaid leave? So he provided me with the letter that the employer had provided to him about what the terms of the unpaid leave were. And that was surprisingly helpful in kind of evaluating, or in helping me evaluate the situation, because it made clear that he wasn't receiving compensation. Obviously, it's an unpaid leave. So that was certainly an issue to me in terms of whether a bona fide employer-employee relationship was being maintained during the STEM period. And it certainly would have, at the very least, triggered the need for a new I-983, because on the I-983, there is information about compensation. It also said that he was no longer making contributions to his retirement accounts. Made sense. That he wasn't eligible for health insurance benefits or COBRA, which I thought was a little surprising during an unpaid leave. And it also made clear that the employer was under no obligation whatsoever to rehire him, and that the position might not be available by the time he sought to return to the employment. So with all of that in mind, that information really made me think, you know what, this is like ending employment temporarily, given this language that the employer is using. And at that point, what we decided to do was that we thought it would be best for the student to submit an I-983 with a final evaluation. We indicated that the employment had ended as of the date that the unpaid leave was going to start. And then, as it turned out, about 6 weeks later, he was able to return to the employment. So we did a new I-983 and did a new round of employment starting and resuming with that employer. But given the circumstances that the student was presenting, we did not feel that that was a situation in which we could indicate that employment was continuing. So I think if you have a student approaching you with questions about unpaid leave during the STEM extension, it really is worth digging into what the specific circumstances are for that student and how the employer is viewing that unpaid leave period. And fortunately, this student had this documented, and the employer, it was a fairly large and established employer, so they clearly had policies in place about how they would typically handle these situations. So that, I think, made things a little bit easier. But I think if you have someone who's telling you that they're going on an unpaid leave, that it's really worth digging into that a little bit more so that you can provide the student with specific guidance that is tailored to what the situation is. If we could move on to the next slide. There are a couple of other issues with STEM, namely changing employers and what the reporting timelines are. We talked about that a few minutes ago. So I'll leave that as is. And then sometimes there is also a discrepancy between the SIP code on the I-20 document and the degree or major field of study used by the school. For example, at the School of Public Health, they have a program in quantitative methods, which is basically a combination of epidemiology and biostatistics. It's extremely heavy on linear algebra and high-level statistics courses. So it's very clearly a mathematics field. And the SIP code used on their I-20s is for epidemiology, which is 26.1309. That is a STEM field. However, when they submit the I-20 that reflects that SIP and the diploma or the diploma and transcript reflecting an MPH in quantitative methods, that has occasionally brought on some confusion from USCIS, not too much, but in that instance, we have had the program director and the registrar sign off on a letter attesting to some details about exactly what coursework is involved, and things have been resolved that way, and we've never had a problem with a denial. So that's something else that you might encounter, and we would encourage people to work directly with the school's academic program, registrar's office, deans, provosts, whoever might be the appropriate point person at your institution, to prepare some kind of form letter that can be used to explain that discrepancy. Some people use those from the outset of STEM OPT applications and just include it. We do not. I think that's something you can evaluate depending on your student population and really what the discrepancy is. That also might come into play. So those are just some things to think about with that. And I think the next slide might be the last one for STEM. Oh, there are a ton of STEM OPT resources. As you might imagine, it's a fairly big reg. These are resources that are all taken from the NAFSA manual. So we hope that they serve as a good reminder to go back to these specific regulatory citations and go back to some of these resources when you're evaluating these sticky situations. And hopefully they will help you work through those so that you can advise students accordingly. And with that, I think we'd like to take, oh, no, we have the SRC. Sorry, Shannon and Anna, we're going to talk about the SRC and whether or not they can help you resolve any of these situations.
I mean, yes and no. I think there's a couple things that to really keep in mind here. And depending on how long you've been in the field, you might have had to unlearn some previous practice with the SRC based on changes that have happened since 2017, January 2017. So the SRC, it's important to know and remember and remind yourself that is run by SIVP and not by DSOs, and they are not a regulatory resource. Please don't call the SRC and ask if it's okay to do something or how to do something. That is going to be a red flag to them about your institution and should be avoided. They're not a regulatory resource. They're also not your friend or your colleague, maybe partner, but not colleague. And their goals are different than yours. So it's really important to remember that they're not trying to, they don't have the same outcome in mind to help your student. That's not what they're trying to do. So be really wary when you call and ask them questions or ask for a data fix or something like that about any kind of sticky case you have. Just keep those things in mind. And as I alluded to earlier, hopefully we're seeing a light at the end of the tunnel. It's been a really rough, 4 or 5 years, and changes are coming, but they're going to be slow and they take time. So if you're using the SRC now, keep in mind that a lot of practice and policies still might be in place from the previous administration. So you need to really approach your conversation and your relationship with the SRC with a sense of caution and set reasonable expectations for your students, for your office, for your institutional stakeholders about what can and cannot be done. In recent years, we've really found that the approach that the SRC has taken is that that very few things are going to be corrected by them. So in the past, it was much easier to say like, oh, I made a mistake, but SRC is going to help me. And that's something that we really took for granted and isn't necessarily the case anymore. Additionally, they have been taking longer to help with corrections and are more so than ever before choosing to deny requests for corrections. So you really have to have all your ducks in a row. You can't expect that they're gonna fix it for you. So it's more important than ever to really be detail oriented, cross your T's, dot your I's. Best practices for using the SRC is to gather every possible thing that you might need for the case before you make the call. Know the difference between a correction, which happens in CVIS under correction management, and a data fix. So I see a question pop up about what is the difference. So the difference is the correction management in CVIS has a very specific scope. So if you haven't really taken a close look at that part of CVIS, I would encourage you to do so. There are like 3 things that you can change within correction management, and anything beyond that is a data fix. If you call for a data fix and it could be done through correction management, be aware that the rep that you get on the phone might not even know that. So they'll put in a data fix for you and then you'll wait, however many days for somebody to look at it. And then you'll get a denial and say, please do this within CVIS. So just because they open the ticket for you doesn't mean that that's the correct thing to do. So I would, for any case, I would definitely take a look at the facts that you have, take a look at correction management. If it seems to fit, try it through there. If it doesn't fit or you're not sure, then you can call the SRC and they'll eventually let you know what they want to do. And then also just really think about the information you're giving the SRC. It's need to know only, it's relevant to the case only, and it's not TMI. We don't want to open up a can of worms on a record if it's unnecessary. And then when you have to, yes, Sandy. So Sandy asked, are you saying that if we do the correction first and it doesn't work, can we ask for a data fix? Absolutely. So sometimes you might ask for a correction within CVIS because you think it might fit in the parameters. Same thing will happen as the opposite. If an adjudicator at SRC looks at it and decides that it's not appropriate to go through the correction process, they will deny it and ask you to do a data fix through the SRC. So I mean, the stakes aren't super high for deciding the appropriate path, but it will delay you. So just if there's especially a time crunch, be really careful which one you choose. If you're gonna, if having to do both is going to set you back or cause a problem. Finally, the best practice that is so easy, yet a lot of us forget sometimes, is to make sure you include all the requested information in your letter of explanation and in the evidence you're presenting. Sometimes the information seems so irrelevant, but if they're asking for it, then give it up front and it'll speed things along for you. I think there might be, yeah, I think we have one more slide of what else we can do here, and then we can open up for some additional questions. So we have a few minutes. So while we're going through this last slide, if anyone wants to put some questions in the box, we'll see what we can get to.
That's great. Thanks, Shannon. I think, you know, some of these are just themes that we have been trying to hit on consistently through this presentation. For starters, going back to the regs, make sure you're clear on what that reg says and what that reg does not say. And I'll take the opportunity to highlight that, you know, sometimes it's not about what the reg says you should do. Sometimes you have an opportunity to establish some kind of policy or practice because it doesn't say you can't do something. You know, that's also a way of thinking about things that might help you as you're reviewing some of the regulatory language. I also think, and I think my colleagues would agree, that in this time, you know, given that we're coming out of the Trump administration and into an administration that we hope will be more helpful, I think it kind of has highlighted the fact that different administrations will handle things differently, and we can never necessarily know how things might look 1 year, 2 year, 5 years, 10 years into the future, because as of now, we could very easily have students who are still working through the immigration process quite far into the future. So we have made it a point to remind students that they are obligated to do certain things like report their OPT, check their CPT I-20s to make sure information is correct and whatnot, as in that they are required to do this for the purposes of maintaining their status. And that is language that has worked its way more and more frequently into some of our communications with students, into some of our one-on-one advising sessions, into webinars that we hold with students. And I think that that's also something to think about, is how are you communicating this information to students in specific kinds of ways. I also make a point of it to resend information to students whenever I can. If they send me an email asking about OPT reporting obligations, I send them the worksheet that we sent them a couple months ago about it. Like, this is the email you got from us. This is the information sheet or the handout that you got from us about this information. Please review it. If you have additional questions, review it and contact me with something more specific. And that seems to get through to them a little bit as well. If you remind them that they've gotten the information before, and you can do this in a polite and kind way. Like I say to them, you know, I'm providing this to you for your convenience so that you have the information going forward. And they seem pretty responsive to that. We've also expanded the ways that we're sharing information with students, holding virtual advising hours on Zoom, Teams, occasionally recording information sessions and webinars in accordance with our institutional policies, adding sections to our website about COVID-19 based FAQs, things of that nature. And we have always taken, and I think we have especially taken this even more seriously than we did in the past, been documenting steps that we take in order to show exactly how much we try and how much of an effort we put into assisting our students with the maintenance of status. And to Shannon's point, this comes from the tone that the prior administration took, the approach that they took with respect to DSOs, which frankly was offensive. I'll go out and say it. I think, that was a real affront to our professional community. And I think one thing that I found, this really struck me, I was having a conversation with someone from the SRC and was talking about, how frequently we remind students of their STEM reporting obligations. And her response to me was, well, those types of reminders and the reminders from the portal are mere courtesies. And I was just flabbergasted by that. It's like we go to such lengths to write emails that are in plain English, that are clear, that are bullet pointed, that link back to relevant websites, and that compile all of this information, and it's a mere courtesy. I think that these are the things that we need to start keeping track of, so that in the event of any future issues, we can say we have made our best and most sincere efforts. And finally, just the last slide talks about working with other people at your institution. And there was a great session earlier this week on engaging stakeholders. And there have been a few articles that NAFSA has shared recently that I think are very much relevant here, and that really hit on the fact that we have to strike a balance that that shows our institutions are taking compliance seriously, but are also really trying to support international students and provide for their needs while they are on our campuses, and to ensure that their campus experiences at our institutions are like the most positive experiences that they can have, where they feel like they are accomplishing their academic and professional goals to their fullest potential. So these are a few things that we think people should be considering. And I do want to leave a few minutes for questions. I'm sorry that we went through things a little bit longer than I had thought, but hopefully we can still get to you. And if not, you are welcome to contact me if you have questions afterwards as well.
Great. Seems like people seem to think it was helpful. So that's awesome. That was definitely our goal, to be helpful. And, these opportunities to gather as a professional community, speaking for myself, are few and far between, but so rejuvenating, and looking forward to being able to gather again in person one day, hopefully soon, and to see everybody again, and hopefully enter a time period where things are a little less stressful for us and our students.
Yes.
Just across the board, less stressful for everyone. So this will be shared on our website, and our amazing email guru Ozan will also send out the link to the recording next Wednesday. So it'll be available to share with maybe people in your office who weren't able to make it today. Feel free to reach out anytime to us and our other resources. And thank you to Nicole for being our Zoom person today. And we hope the rest of you take advantage of the rest of the SIW sessions to come.
Shannon, I just saw one quick question. I'm going to take the opportunity to answer it. Someone asks, what are your thoughts on uploading the I-983 in CBIS, given that it's optional? My institutions take has been to not upload it. I don't think we would upload it because it is, as you rightly point out, optional, and we are generally adverse to providing any government agency with more information than what they are specifically requesting.
Yes, for those of us who have been in the field for long enough to remember our amazing friend James Leck, we like to call it the James Leck rule: provide what they ask for and nothing more. Don't give them extra ammo to find a problem.
Yes, same at Bentley. We do not upload since it is not a requirement. There was also a question about whether the presentation will be available so that participants can access the links.
We can talk about how to make it available to the region, but if anybody in particular for sure knows they want a copy, you can reach out to any of us and we'd be happy to share it with you.
Thank you so much, everyone.
Yes, thank you so much. Have a good afternoon, everyone.
Have a good afternoon. Happy spring. Okay, bye.